Good morning, everybody. Good morning. Good morning. I'm your host, Supreme Litigant, and I'd like to welcome everybody back to Smart Loc TV. Before I begin, y'all already know the routine. If you haven't already, please go ahead and hit that like button, that subscription button, and turn that notification bell on. Before I begin, I'll give y'all a second to do that. All right, so let's jump right into this. So this video will be the motion for summary judgment video. I'm going to do it from start. I'm just going to start it just to give y'all an idea of how to actually draft a motion. Um, this motion for summary judgment uh, is a motion that was filed against me in my case. That's me, the plaintiff. These are the defendants. This is the court that it was litigated in. This is the cause number. But I don't like the way that theirs is drafted. I don't think it's detailed enough in regards to just basically showing you how to start the motion. So what I'm going to do is, like I said, I'm going to start it from scratch. So when I say from scratch, I mean like see how there's nothing here? That's what we're going to do. So before I do that, I'm going to let me go check these local rules. Because you have to when you're litigating in federal court, you need to not only follow the federal rules of civil procedure, federal rules of evidence, or the federal rules of appellate procedure. That's if you're doing an appeal. You also need to follow the court in which you are litigating in local rules. That's what they call them, local rules. So let me go back to it right here. Okay, so this is the court. And right now I'm searching for the local rules. That's what I'm looking for right now. Jury info. It should be. Let me see where it's at. I know it's on here. Somewhere. There they go right there. Local rules and general orders. So click that. And here we go. Right here. Let me see if they might have modified these. Because that looks like, was that probably about 8 or 9 years ago. These are all the standing orders. It should be in here. So we'll see. Let's check and see. And they in the PDF file, it should tell you the last time it was amended or something like that. Effective August 25th. Well, I'm guessing they didn't change it, so they probably didn't. William Steele, Chief Judge. I don't know if he's the Chief Judge anymore. I don't think he is. But anyway, make sure that you have an updated version of these local rules. Make sure you do that. So since we're doing a motion for summary judgment, you want to go to, was that 56? You see there it is right there, judgment. Civil Local Rule 56. That's how they want you to cite it to. Summary judgment. It's going to be on page 45 in this PDF file. So we go to 45 in this PDF file. And it's going to tell you how this particular court wants it done. So it says motions for summary judgment must comply with Federal Rule of Civil Procedure 56 and Civil Local Rule 7. Okay, so that means we have to go back up and read Local Rule 7. With the exception of Social Security reviews, other actions for review of administrative agency decisions, and other actions in which a judge relieves the parties of this rule's requirements, the following additional requirements must be met. Movements supporting material. The movement must file a brief that includes 1. All facts relied upon, each supported by a specific pinpoint citation to the record, and 2. Arguments supported by legal authority as appropriate. The movement, meaning the one moving for summary judgment, must also file all evidence relied upon. So that means your exhibits. A movement seeking affirmative relief other than or in addition to monetary damages, such as declaratory or injunctive relief, must file a proposed judgment, not order or opinion, granting such relief in the form sought by the movement. No other supporting documents may be filed absent court order. Non-movement's response, movement's reply, effective uncontroverted facts. I think I'm gonna read y'all all of that. Just to show y'all how important these local rules are. You have to make sure you follow all of these rules. Non-movement's response. Unless the court orders otherwise, the non-movement the non-movement must file any response in opposition to the motion within 28 days of service of the motion. The non-movement's brief must include all facts relied upon, each supported by a specific pinpoint citation to the record. 2. All challenges to the movement's asserted facts. And 3. Arguments supported by legal authority as appropriate. The non-movement must file all evidence relied upon. No other supporting documents may be. So it's essentially the same thing as a movement's reply. Unless the court orders otherwise, any reply must be filed within 14 days of service of the non-movement's response. Effective uncontroverted facts. The court will deem uncontroverted material facts to be admitted solely for the purpose of deciding the motion for summary judgment. Stipulated facts. Parties are encouraged to stipulate to facts. Facts so stipulated do not require reference to evidentiary support. Let's see, modification of provisions in particular cases. That's Rule 62. So that'll be it. So it looks like it stops at F right here in the local rules. So give me a second, y'all. I'm gonna pause this and I'm gonna go right up here to Civil Local Rule 7 and just to read it and see what it says. All right, y'all, we're back. So here it is right here. See right there? That's the rule. Form of motion. Every motion must state the statute, rule, or legal or equitable principle pursuant to which it is made. See, let me stop right there. Let me show y'all this motion. Defendant's motion for summary judgment. See, I could have, just because they didn't, I'm of the opinion that just because they did not bring this motion by a rule, like they were, like this rule, what is it, Rule 7, like it requires that local Rule 7, like it requires, I could have moved to strike this motion for summary judgment because they violated that rule. Let's see. B. Movements supporting materials. Except as ordered by the court, any motion filed pursuant to Federal Rule Civil Procedure 12B or 56 must be supported by a brief. For other motions, supporting briefs are required where necessary to set forth the legal and factual basis for the relief sought. A supporting brief may be included within the body of the motion. Absent court order otherwise, any brief, exhibit, or other supporting paper must be filed contemporaneously with the motion. Failure to file a brief in support of a motion under Federal Civil Procedure 12B or 56C, or 56, is sufficient cause to deny the motion, and failure to file a brief may be sufficient cause to deny any other motion. Movement's response, movement reply, blah, blah, blah. This just shows like they're very, very picky with how they want this stuff done. These are the judges, the so-called judges' rules that they have fashioned with how with dictating or instructing how they want cases litigated in the courtroom. Non-movement's response, unless the court orders otherwise, the non-movement must file any brief, exhibit, or other paper in opposition to a motion, except a motion under Federal Rule Civil Procedure 56 within 14 days of service of the motion. Failure to file a brief in opposition to any motion other than blah 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 may be sufficient cause to grant the motion. Movement's reply. Unless the court orders otherwise, any reply in support of a motion, except a motion under Federal Rule of Civil Procedure 56, must be filed within 7 days of service of the non-movement's response. length of the brief. See how they're very specific with what they're talking about and what they're asking for. Principal briefs in support of or in opposition to any motion must not exceed 30 pages, and reply briefs must not exceed 15 pages. These limitations exclude any caption, cover page, table of contents, table of authorities, and signature block. No brief exceeding these page limits may be filed unless the court has previously granted leave to file a brief in excess of these limits. Citations. I'm not going to read the rest of this stuff, but this just I'm trying to show y'all how important it is to find and locate these local rules when you are litigating your 42 section 1983 lawsuit in federal court. These rules also apply to criminal cases, just to let y'all know. So let me show y'all what I'm talking about when I say that they apply to criminal cases. They've separated the rules. They're labeled civil and criminal. So you're going to see all the civil rules first. All right, those are all the civil rules that they've modified within this district, U.S. District Court. Now you see criminal rules. See what I'm saying? So you need to make sure when you're litigating cases in a U.S. District Court that you follow these local rules. Okay, let's get back to the motion for summary judgment. I'm going to show y'all how I do mine. Give me 1 second, y'all. Okay, I think I need to read this other rule to y'all from the Federal Rules of Civil Procedure before I start drafting the motion. So that's what I'm gonna do. Motion for summary judgment. So when you draft this motion for summary judgment, it's gonna be a Rule 56A motion. 56C, it just tells you what to do, the procedure for doing it. A motion for summary judgment or partial summary judgment. A party may move for summary judgment, identifying each claim or defense, or the part of each claim or defense on which summary judgment is sought. So what they're saying is you can motion for summary judgment on some of your causes of actions or on all of your causes of actions. The court shall grant summary judgment. I want y'all to pay attention to this. This is very important, what I'm about to read. Because this is the standard that you need to meet in order to get summary judgment granted in your favor. And this is also the standard that you need to meet if you are a defendant to defeat summary judgment against you. The court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. I'll explain to y'all what as a matter of law means right now. So as a matter of law basically means this. It means based on all of these facts that you have presented to the court, the law requires us to rule this way. That's essentially what it means. Since it's a matter of law and the facts are no longer in dispute, you're not arguing over the facts. And we have applied the relevant case law to this particular set of facts. The case law mandates that we rule in this way. That's basically what it means, y'all. The court should state on the record the reasons for granting or denying the motion. Time to file a motion. Unless a different time is set by local rule or the court orders otherwise, a party may file a motion for summary judgment at any time until 30 days after the close of all discovery. So they can file it before discovery, or they can file it 30 days after the close of discovery. Procedure, Rule 56C. 1. Supporting factual positions. A party asserting that a fact cannot be or is genuinely disputed must support the assertion by A, section A, I'm sorry, citing to particular parts of materials in the record, including depositions, documents, electronically stored information, affidavits or declarations, stipulations, including those made for purposes of the motion only, admissions, interrogatory answers, or other materials, or B, showing that the materials cited do not establish the absence or presence of a genuine dispute, or that an adverse party cannot produce admissible evidence to support the fact. So, depositions, documents, electronically, all of this stuff that you get this through discovery. So, when you're going through discovery, what you want to ask for is evidence in support of all of the facts in your complaint against whoever it is that you're suing. That's what you're doing. And they are what the defendants are doing is they're asking you for evidence in support of your facts and in support of their claims against you. When I say claims, let me rephrase that. Their defenses against your causes of action. So their defenses meaning qualified immunity or something like that. Whatever it may be, equitable estoppel, that may be applicable. Statute of limitations, that may be applicable. Stuff like that. They're asking you for all of that evidence to use it against you, and you're asking for evidence, relevant to your case to use against them. That's all you're doing in discovery. That is it. I'll make like a series of videos showing y'all how to let me see, do interrogatories. This is what they call it, request for admissions, interrogatories, request for productions. You should know how to do affidavits and stuff like that. It's pretty easy. I'm not going to read all of this stuff within this particular rule, but you should when you're litigating your case. I just thought that this was in my opinion, the most important part that I wanted y'all to know. So let's get back to the motion. And I'm going to show y'all how I do mine from scratch. So we're going to start, where is it? Response to motion for summary judgment. So right now I'm going to copy and paste this. All right, I'm going to copy and paste this. I'm going to show y'all how we do it. Boom. This is how I do mine. Very easy, y'all. Let's see. We're going to make this Times New Roman. We're also going to make that 12. We're going to bold it. Make this back one. I don't like how close that is. So we're going to space it apart. Probably, it ain't too bad right there. Put another space in between now. Cut it a little. That's okay. We'll leave that like that. And you want to title it, let's do plaintiffs. Motion for summary judgment. All right, I'll spell that right in a minute. Boom, judgment. There we go. Go down here. See how quick I did that, y'all. This stuff is so easy, man. It's just that easy, y'all. I'm a little detailed, so y'all gotta bear with me. I just like to do my stuff very detailed as possible. All right, everything is looking good so far. All right, we'll take that out. So let's go back to here. Was it right here? And I'm gonna copy this. Ooh. Make that bold. I'll make that a little smaller. I like that. Plaintiff. We're gonna say the following. We're gonna say. Always bring a motion by a rule. Pursuant to Rule 56A of the Federal Rules of Civil Procedure and looks like it's going to be yeah, it is. I like to highlight the rules. I think that's easier for people to understand and locate the rule, and it's easier for the judge to, so-called judge, to know that I'm following the rules. They know exactly which rule it is. That was local rule. How do they want that cited? You have to cite it how they want it cited. I don't like the way it looks, but I'll do it. Where is it at? Right here. So I think that's local rule. They're going to tell you how they want it cited in here. So it's going to be Civil Local Rule 7. Pursuant to, and was it and Civil Local Rule 7, I think. Rule 7. And we're just going to copy this because we're using 56 too. 56. We're going to say for summary judgment against I'm gonna leave these names in here since they are already in here. Against Holyfield. I like to use this and symbol right here because it saves space. It's Holyfield and I'm gonna take officer out there and Breland. Here and after defendants or severally Holyfield and Breland. And then we can just say something like, hold on, let's go back. Okay. We just say, and then I like to do this. In support, I spelled that wrong. In support of this motion, plaintiff avers the following grounds. This is how I like to do mine, y'all. Make that black. Boom. Uh, I'll leave it like that. Make this bold. And I like to double check to make sure that I'm following the rules. For summary judgment against holding. Um, let's see, verse. The following grounds. Now, I don't want to make this too complicated for y'all, but once I do something like this, then I would go back and I would look at the local rules to see if I've cited the correct local rule. Where's that? That's not it. So we got 7. It's on page 31. All right, let's go. Where we at here? We'll go down here. And we type in plaintiff contemporaneously. Contemporaneously. I probably spelled it wrong. Contemporaneously files a. We're going to title this memorandum. Memorandum. Spelled that wrong. Of law in support of plaintiff's motion for summary judgment. Let's get this capitalized. And incorporates same herein by reference. Easy, y'all. Easy. All right. I would there's gonna be some exhibits. Well, you can how I would do it, you can attach the memorandum, to this motion for summary judgment. And all of your exhibits you need to attach to your memorandum of law in support of your motion for summary judgment. That's how I would do it. I would go down here. I would do a signature line. Let's see. I like to do mine like this. So I would do a signature line. Something like that. Probably, you can put your address, like your address right here. All that address, email, phone number, blah, blah, blah. You can put all that stuff down there. You can do, I would advise you to do a certificate of service also, because you want to make sure you serve everybody. So you would just do, this is basically how you do a certificate of service. You put it right here. Let's see, I like to put mine right here in the middle. Go down, you would say, I certify. Let me see if I can find it right quick. Let me go back. Certificate of service. You would, let me pause the video right quick, y'all. Give me 1 second. Okay, so what I did was I had to find a certificate of service that I typed up. So basically, you would just say, I, the undersigned, hereby certify that I have complied with service whereby furnishing a true and correct copy of the above to all parties on this whatever day of the week and month it is, and then you would sign it electronically. That's essentially what a certificate of service is. Now, you can also, if you want to be very detailed, you can add the addresses, the names, addresses, phone numbers, or email addresses, either right here, right here, of all of the parties to the case, or you can just leave it like this. I don't think it really matters in regards to that. Let's see. Now, right now, I need to go to the layout. So what I'm gonna do now is go back to this document. All right, and we'll just end that there. We're gonna put everything on another page. So right now, what are we doing? We're gonna draft a memorandum of law in support of plaintiff's motion for summary judgment. See how? So what you do, you just copy and paste that, the case citation. I mean the case head. I forgot what they call it, form or whatever you want to call it. Caption, yeah, the case caption. And you don't want to, like, I don't want to type all this no more. So I'm gonna copy and paste that. You feel me? And I'm gonna put that right there. Get that out the way. We'll do something like this. Take that out, spelled that wrong, so we got to spell that right. Yeah, we'll make this a little bigger. Put that at about a 12 maybe. Yeah. Put that at about a 12. And then you start pleading your case. Let's see. I have to figure out now how I want to lay the document out. So I'm going to have to pause the video again to show y'all how to lay the document out. So give me a second and I'll be back. All right, y'all. So the first thing that you would need to start out with, in my opinion, now you may not see other memorandums done like this. They may do it a little different. But I like to start out mine like this. With a factual background of the case. I can just do it right here. And everything under here, I like to make this a little smaller. So since that's a 12 font type, we're gonna make that into an 11. So a factual background. And here in this particular section, you need to talk about, you know what, let me make this, we'll do it like that. A relevant factual background. Because you only want to talk about stuff that's relevant in this. So everything that is relevant to the facts of your case leading up from when you initiate the case in federal court all the way up into the closing of discovery. You want to talk about that. So you'll say on such and such day, I filed a lawsuit on January 1st, 2021. The defendants answered the complaint. Maybe they answered the complaint February the 1st, 2021, something like that. And after every sentence, or after every we're going to say sentence, after every sentence within this section, you need to cite a document in support of what you're saying. So you're going to use the court's docket to do that. So when it says, like we just said, I filed my complaint on January 1st, 2021, at the end of your sentence, you'll say something like, see See Doc 1. Something like that. See what I'm saying? This stuff is very, very, very easy, y'all. See Doc 1. Okay. You don't want to make it too. Don't say any more than what is necessary for you to get your point across. You don't want to make it too wordy. Okay. Okay. Next, you want to have, what is it? The legal standard. Remember when I was talking about legal standards, y'all? Because right after your legal standards, you're going to start making your arguments. So let's see. I'm going to go and find the legal standard for summary judgment right now. Just give me 1 second. I'm going to pause the video and I'll be right back. Okay, y'all. I just wanted to update y'all on what I was doing. So when I paused the video just now, I'm looking for cases right now to give y'all a better explanation of the summary judgment legal standard. So that's what I'm doing right now, and I'm doing this for the 11th Circuit because I litigated my case in Alabama, so in a U.S. District Court in Alabama. So I'm looking only at 11th Circuit or either some Georgia, Florida, or Alabama U.S. District Court opinions. That's what I'm looking for right now. So I just want to show y'all this. This is how I do my research. So once I find the right case, then I'm going to unpause the video after this. So I'll be right back. All right, y'all, I'm back. I think I found the perfect case. I just copied and pasted. I think it's this case right here. It's a bankruptcy case. So I'm not going to include all of what I just copied and pasted in here. But what I did was, let me show you. I scroll down to here. See where it says standard for motion for summary judgment. I copied I copied this and I'm gonna paste most of it into the document for y'all. So I want to show y'all something. So we're gonna do this right here. We're gonna talk like this. We're gonna call it legal standard for motion for summary judgment. Might have spelled judgment wrong. Yeah, probably did. I knew that. So we're gonna do this. I like to put mine in the center. Correct that. Legal standard for motion for summary judgment. Let me see. All right, I like that a lot better. That one looks better. So we're gonna go over here, and now what I'm going to do is I'm going to paste this into there that I just got. See how I did that? It's just so easy, y'all. So easy. So right now, what I'm gonna do is I'm going to edit this right here to fit what I wanted to. I mean, to basically to say what I wanted to say. I'm going to make this fit my case. I read over this. I thought it was pretty good, and I think I'm gonna read over it to y'all in this video because I think this is some pretty good information to point out. So I'm gonna read it to y'all in this video. I normally make my stuff look a little better than this, like for example, all of my cases, they'll be highlighted like this. Cases like this. I like to do my cases like this, or I'll just put a footnote in it. I might copy and paste that. Well, we'll leave it alone. But what I normally do is I do this, and I'll make it a little smaller. Since it's in bold, I'll make it a little smaller, and I make everything. Hold on, I think I did that wrong. Let's go back. Yeah, I did, and I'll make everything black like that. That's normally how I do my stuff. So what we're gonna do? So I would say, instead of doing this, I would say rule. Hold on. Give me 1 second. So I'm taking this out right here. And I would say I would redo this. Let me show y'all how I do mine. Y'all don't have to do yours like this, but this is just how I do mine. Okay. So I will copy and paste that, and I bring it down here. I would say, whoa, sorry about that. I would do something like this. Rule 56A of the Federal Rules of Civil Procedure provides for the granting of summary judgment if the pleading, you see what I'm saying? Something like that. I will remove this because this is irrelevant. So what I'm going to do, I'm going to read y'all this standard for summary judgment. This information, I think this is very good information in regards to summary judgment that y'all need to know. So I'm going to read it to you. Rule 56A of the Federal Rules of Civil Procedure provides for the granting of summary judgment if the pleadings, depositions, answers to interrogatories, and admissions on file, together with the affidavits, if any, show that there is no genuine issue as to a material fact and that the moving party is entitled to judgment as a matter of law. That's 56C of that rule. The burden of proof with respect to a motion for summary judgment rests on the moving party. That means if you're moving for summary judgment, then the burden of proof is on you to show why your motion should be granted. Once the moving party has met its burden, the non-moving party must then establish an essential element of its case for which it bears the burden of proof. Absent such a showing, there is no genuine issue of material fact. Scroll down a little bit more. However, the requirement for a genuine issue of material fact is not satisfied by the simple existence of a dispute between the parties. And there's the cases. See all this stuff? These are all the cases where they're these are all the cases that they're citing in support of why they're saying what they're saying in here. Only disputes over facts that might affect the outcome of the suit under governing law will properly preclude the entry of summary judgment. Factual disputes that are irrelevant or unnecessary will not be counted. When a motion for summary judgment is at issue, the court is required to view the facts in the light most favorable to the non-moving party. That means the party who did not move for summary judgment. If the court then determines that reasonable minds can come to but one conclusion, and that conclusion is in favor of the moving party, the court must enter the judgment. In other words, the motion must be granted if the court is satisfied that no real factual controversy is present so that the remedy can serve its salutary purpose in avoiding a useless, expensive, and time-consuming trial where there is no genuine material issue to be tried. However, if reasonable minds could reach different conclusions, the court must decline to enter the judgment. So, what this is essentially, what a summary judgment motion is it is a motion um, that will is going to be decided by the court. So what you're going to do is, it's like you're saying, you look, Your Honor, we have all of the facts, we have all of the evidence that we need in support of those facts, and we have the case law, the relevant case law um, that suggests that we don't need to go to a jury for the jury to decide um, that these defendants violated my rights. So I would like for you to determine that, Your Honor. I don't want to go to trial. I think we can do that. I think you're capable of doing that. So I'm going to file this motion for summary judgment. I'm going to cite all of the evidence in support of my arguments, the case laws, the depositions, the affidavits, the request for admissions, the request for productions, the subpoena ducis tecum, everything that I've used in discovery. I'm going to cite all of the relevant stuff that I need that is necessary to support my arguments. That's basically what you're doing. That's pretty much it. Okay. The next thing you would do. So we're gonna skip down. We'll go to the next column. Now that you know the legal standard, you might say something like, we're gonna title this. We'll say plaintiff is entitled to summary judgment. Y'all give me 1 second. Hold on. All right, y'all. Sorry about that. So plaintiff, pick up where we left off. Judgment. I had to get me something to drink. Plaintiff is entitled to summary judgment as to his first cause of action. Hold on, y'all. Something's going on. Hold on. All right. Yeah. Okay. Sorry about that, y'all. So, yeah, you want to do it like that. Let's see if I can make this right here. Yeah, I would have mine looking like this. I would go down, and in this particular section, I would say, I would title it Plaintiff's Arguments. Let's go here. We'll put that here. We're going to capitalize it, make it a little smaller. Make this darker. And since I think that's too much space in between there, we will do that like that. And then you would you would argue your case right here. This is where you would argue your case at. Plaintiff is entitled to summary judgment as to his first cause of action. How you would do that is, you would make an argument, and then you would cite somewhere in the record, whether it be from a deposition, a request for admission, a request for production, some sort of video evidence, some interrogatory, whatever. After you make the argument, in a so-called sentence or whatever, then you would say, "See doc." Let's say that you're the proof that you're directing the court to is in an interrogatory. You would say, "See plaintiffs." Well, no. Let's say we're going to call your everything that you got from discovery. We're gonna title them with exhibits. So exhibit 1, 2, 3, 4, 5, 6, 7, whatever. It'll say see exhibit 3, paragraph 1, something like that. That's how you got to do it. It'll be so much easier if y'all can see. So I got a better idea. So what I'm going to do is I'm going to go to the defendant's motion for summary judgment, and I'm going to show you what I mean right here. So let's see. I'm going to see if they're going to cite an evidence in support of their argument, and they should in here. Where is it at? Give me 1 second. I'm going to pause this video. I'll be back. All right. So here's an example of what I mean, y'all. So this is, they're making an argument here. He's saying, Davis thinks this incident in question occurred the first or second week of February 2019. You see where he says, see exhibit 1, Davis deposition, paragraph, or I don't know if that's paragraph or page 38 through 42. That's how you have to do it. You have to do it just like that. You're directing the court to the evidence in which you are relying on in support of every argument you are making in your motion for summary judgment. That is what you're doing. It's very easy, but this is the most longest motion that you will probably ever do. I hate doing them. I can do them, but I hate them because they just take so long. But that's pretty much it, y'all. That's how you do the motion for summary judgment. You have to do it for every single cause of action. You're just repeating the same steps over in how you're arguing your case. That's it. So let's go. We'll go down here to the end of the. I think it's on page. I think it's about 30 pages, maybe. So let me see. This is the defendant's motion for summary judgment in my case. So that's their exhibits. So this is, remember when you just saw exhibit 1C deposition page, blah, blah, blah. So they attach the exhibit to their motion, to their memorandum in support of summary judgment. And this is the deposition. This is the actual deposition. A deposition is basically an out-of-court proceeding. It's when you go to, I had my deposition at the attorney's office. Who represented the defendants who I had sued. So he had a court reporter in there. There was a microphone. There was a video camera in there recording everything. And they take your testimony under oath. So you have to, I swear to tell the truth, the whole truth, nothing but truth, blah, blah, blah. That's what a deposition is. And he's just answering you questions. He's just asking you questions. So it was just me, the attorney, a court reporter, and a videographer or whoever he was, somebody recording everything. That was it, y'all. It wasn't nothing else. That was it. And we're sitting in the office, the meeting room for the attorney during the deposition. That was pretty much it. Let me see if he should be citing other stuff too. I'm gonna see if it's in here. Scroll through this. I'll let y'all see this. I was gonna stop it, but I'll let y'all see it. Well, you know what? I'm gonna stop it because I don't want to bore y'all with all this stuff. So hold on. Okay, this is the defendant's request for admissions. They were asking me questions. Like, for example, on the date in question, you refused to give your name to Officer Breland. Admit or deny. So they want me to either admit I did that or deny that I did that. You refuse to give your full name to Officer Brandon Breland. Admit it or deny. You were driving an automobile on the date in question. The automobile you were driving broke down on Highway 43. Admit it or deny. Admit or deny. You exited the automobile. Admit or deny. Admit or deny. So what they're trying to do is we're trying to narrow the issues down. So if I admit to anything in here, it's called a stipulation. It's an agreement. Once it's stipulated, then it becomes a fact. So once I agree to it and they agree to it, then it becomes a fact. And it's no longer in dispute. That particular fact is no longer in dispute. You refuse to produce your driver's license. Admit or deny. Officer Breland asks you for your driver's license. Admit or deny. Something like, you see how simple this stuff is? It's very simple, y'all. So this is what he gave me. He served me these discovery questions. And so you should see my answer right behind this. My responses to his request for admissions. So here's plaintiff's response to defendant's request for admissions. Admit. Request for admissions. Admit as to Officer Breland exiting his patrol car, denies remaining request for admission. Something like that. You see what I'm saying? Now, you can make objections when they're asking you questions in discovery, like I did right here. Objection. Plaintiff avers that this request for admission is wholly irrelevant, whereas it does not relate to any fact which is of consequence to his claim. So the reason I objected there is because the question is irrelevant that they're asking me. It's irrelevant. It has nothing to do with the case. So I objected. I thought it had nothing, so I objected. If you think questions or documents or whatever it is in discovery that they're asking you for is irrelevant, object to it. Don't answer any questions unless you ordered to by the judge. Deny, admits. It's just simple. Simple. Very simple, y'all. Exhibit 3. What is Exhibit 3? Oh, that's an affidavit. But I just want y'all to know. I want y'all to see how they're using testimony from actual witnesses in support of their motion for summary judgment. You're not going to see a motion for. You're not going to see any affidavits, requests for admissions. You're not going to see the attorney. What I'm trying to get you to understand is you're not going to see the attorney attempting to testify at all in my case. They will try to misconstrue the evidence. They will do that. And when they do that, that's up to you to correct them, to dispute what they're saying. Let's see what else. I'm gonna go down to the bottom of this. Let me see. Is it on page 30 yet? I might have hold it down too long. Probably did. Yep, I did. Too long. So let's go back to page 30 because right now we're just gonna close the document. So, for example, when you finish your motion for summary judgment, you want to say you can either do conclusion or you can say wherefore plaintiff respectfully requests this court grant his motion for summary judgment as to his first cause of action, second cause of action, third cause of action, fourth cause, whatever. It's just that simple, y'all. It's just that simple. So since this is a qualified immunity type thing, let me rephrase that. Since this is a 42 section 1983 lawsuit, and we're going to be arguing obviously qualified immunity, stuff like that. So you're going to be litigating that issue of qualified immunity. So you're going to be arguing your case why these police officers should not be entitled to qualified immunity. Any type of immunity or any type of affirmative defense that they are asserting that they have, you want to dispute that. You want to show all of the evidence in your favor suggesting that they don't have immunity as a matter of law, that they are not entitled to any form of immunity as a matter of law. That's all you're doing, y'all. That is all you are doing. It's not hard. It's not hard. And yes, y'all can do this. I want to I'm gonna see. I may have to have these. I may have to split the screens if I can and have them side by side where you can see their first argument, where they're arguing that they're entitled to qualified immunity on my first cause of action, and then I'll have my response in opposition, arguing against them, and we'll compare the arguments to just tell you what I'm disputing. I got to figure out how to do it because I don't think I know how to do it. But I think I covered pretty much everything in this video in regards to summary judgment, just the basics. If I didn't, if there's something else that you want to know, let me know. And I'll try to do like a part 2 to it just to let y'all know. So hopefully this helped y'all understand this. I can't really think of anything that I missed right now. But this is basically, let me go back to it. This is basically how you draft a motion for summary judgment. It's very simple, y'all. Very, very simple. You can do it the way you want to do it. But I'm very detailed with my work. Like all of this stuff would be so neat if I actually took my time. It'd just be extreme. It'll be very neat. For your next one, like as to your first cause of action, you would go down. You would say plaintiff is entitled to summary judgment as to his second cause of action. And then after you made that argument, you would say plaintiff is entitled to summary judgment as to his third cause of action. Just very simple stuff. Very simple stuff. So anyway, I'm going to go ahead and end the video because I think this was pretty decent. So I'm going to end this video. Hopefully it helped. If it did not, you have any questions, just post your questions below. That will be it. The Supreme Litigant is out.